A public employee seeking a new job has conflict of interest restrictions on his job search only if his responsibilities in his public position affect or involve the potential employer. A job-seeking public employee who has no responsibility for anything related to the potential employer has no issues under the conflict of interest law in connection with his job search. However, if the public employee is responsible for matters involving the potential employer or has dealings in his public position with the potential employer, the conflict of interest law will impose restrictions to prevent the public employee from using his position to improve his employment prospects, and also to prevent the public employee from favoring the potential employer's interest over the public interest, or from even appearing to do so. A public employee seeking new employment with persons or entities who have no connection with his official responsibilities is not prohibited by the conflict of interest law from seeking such employment. The law only imposes restrictions on public employees seeking new employment when there is, in fact, the potential for conflicts of interest, because the public employee has official responsibility for matters involving the potential employer, or has official dealings with the potential employer. Forever ban. The broadest restriction on former public employees applies to particular matters in which the public employee participated personally and substantially in his public position. A public employee has a lifetime ban, the so-called forever ban, on being compensated by, or acting on behalf of, a new employer in connection with any particular matter in which he participated personally and substantially in his former public job. He can never become involved in that same matter after leaving public service for anyone other than his former public employer. A public employee need not have been the ultimate decision-maker in a matter for the forever ban to apply. He will be subject to the forever ban if he participated in discussions about the decision, or gave advice or made a recommendation about that decision, and he will not be able to work on that same matter for a new employer. To 23. However, participation that is merely ministerial and not part of the decision-making process, such as, for example, mailing a letter, will not be considered personal and substantial, and the forever ban will not apply.